Cheers.
Thank you, panelists. Hello, hello. Is this working? Yeah, here we go. Okay. So we're now going to be back to some standalone presentations. And we're going to start with Jeff Karras. NFTs are now collateral for secured loans. Are you legally protected? Jeff. And I guess you can, I'm told I'm supposed to keep this. You can use this or any of these. Your choice.
Are these working? Yeah? Okay. Okay, so first, I know we've all heard the word security 100 times today, and even though it says secured up there, I am not talking about securities, so you're either going to be very bored or find it interesting and refreshing that I'm talking about something different. But my name is Jeff Karras. I work at Anderson Kill now. I've been doing Web3 specific law for about 2 years, but before that, I was doing private equity debt finance in secured lending space. And so in pretty much any lending transaction, you're going to have the lender giving temporary money in exchange for interest paid, and the borrower will pay that interest for immediate liquidity. And that's true of a car loan, that's true of a billion-dollar company-wide leveraged finance, and it is now true in the NFT space. Several platforms are starting to do this. A lot of it is specifically on-chain, and I'm not quite sure if they are legally protected in the lender's sense. And that is because what happens when you default on your loan. Now, in the used car space, you go buy a car with money from a bank, presumably. If you don't pay it, they take your car away. It's very simple. And lenders in this space are protected by the Uniform Commercial Code, Article 9, and there's a long history of protections in this space, and a lender in the used car space is very confident that they are legally protected if they want to go after that borrower for that used car. So in the NFT space, it's a little bit more difficult, just because we don't quite know what they are according to UCC Article 9. It's certainly not a car. It is probably not art, according to the definition in UCC Article 9. So what is it? It could be a general intangible, and that is sort of a catch-all category in Article 9 that we often use to just throw everything else in. The problem with that in the NFT space is you are perfected, which means you let the government know so that you can then go back and collect on your loan later. You're perfected on a general intangible via this form, a UCC-1. And this form requires you to know what jurisdiction to file in, requires you to put the address and name of your borrower. And I don't think the Delaware Secretary of State will let you just put in, moonboy_69 as the name of your borrower. So this is probably not the preferred method of perfecting an NFT loan. So if it's not a general intangible, then it is most likely an investment property, similar to fungible tokens. And the way you are perfected on investment property under UCC Article 9 is what's called control. Now, control can be defined, or you can have control in a couple of different ways. One is that you physically have it, and that is probably not going to be comfortable for a lot of the borrowers in the space. I know plenty of people in here would probably not want to just give their NFT over to a stranger in the hopes that they give it back later when you pay their loan. So what is most likely the case here is a three-party agreement between the lender, the borrower, and a third party. And these, in the typical lending space, are usually called account control agreements. And how this works is you have the NFT, the borrower has the ownership of that. They actually transfer it to a third party who has custody of it, and then that third party signs an agreement with the lender that essentially says, if the borrower does not pay me, the lender, what I'm owed, you have to answer to me instead of the borrower in reference to what happens to this collateral that is in your custody wallet. And so this is how it works in many lending spaces now, and typically this third party is a bank. Now, I don't have to tell this room that banks are not exactly our preferred third-party people in the decentralized space. So the question is, who's going to step in and be this third party? Some people have tried. Like I said, there's some on-chain solutions here. I've poked around them. You know, I am not a programmer in any sense, so I don't exactly know what is in that smart contract, but I do know that there's no terms and conditions or anything that you're clicking through that is agreeing that this third party has control or any of that sense. So, you know, it's happening, and there's also other things, you know, very specific over-the-counter, individual you have to apply, and that might be a little bit more legally involved since it is on the individual basis and not kind of the scalable on-chain. But, you know, what's clear is that we probably don't have a perfect solution to this yet. And like most things in this space so far, nobody really cares to solve the nitty-gritty legal problems until there's a big issue that makes headlines or somebody loses a bunch of money. But I do know that we as attorneys should probably be ready for this. So if you guys all have a copy of your UCC, you might want to hold on to it for the inevitability of this coming up, because I'm sure it's going to be happening soon. That is my very short, very niche discussion about that. If you guys have any questions, I think I still have a few minutes. Anything about secured lending? Go ahead. So I've had this conversation a couple times this week. The issue is that the escrow wallet, you're getting into the code is law concept, right? Where a programmer will definitely tell you that, well, it's automatic, and so therefore, why would we have to worry about being perfected under the law? And that might be true, but the issue is if that smart contract fails for some reason, or that borrower is able to move it to another wallet for any reason, you have no legal recourse if the contract fails. And that's kind of what I'm talking about, is that next step when the smart contract platform doesn't follow through or somebody finds a loophole in it. If you're a lender, then you might not have any recourse if you're not doing it properly in one of these ways. Does that answer your question a little? Okay. Anything else? Go ahead. What's that? That is a question for somebody else on a different panel. Fascinating conversation to have at happy hour later, for sure. But yeah, I know there's appraisers that are out there. People are trying to do it with an algorithm, which scares me personally. But obviously the scalability of personally appraising each NFT that comes across your platform doesn't really work either. So yeah, that is definitely a very, very interesting question. And then there's the whole, when it falls below a certain thing, are you automatically liquidated, all that kind of stuff too. So, yeah. What's that? Liability for what? I'm sorry, it's hard to hear you from the back. Yeah. I think I hear your question. If they are securities, like how does that work? Securities fall into the investment property basket pretty squarely. So that's, I think, again, I'm not answering whether or not each NFT is a security, but if they are, it's actually easier to answer this question because that is an investment property. So, okay. All right, I think I'm out of time, but I'm around and obviously online and everything. So thank you, everybody. I enjoyed the questions too. Have a good day.